Well, good afternoon, and I think I can say that to all of you, including those of you joining us on Eastern Standard Time. I'm thrilled that we're joined by so many of you across so many jurisdictions. For those of you who don't know me, I'm Jessica Henson. I'm a partner at Payne Hicks Beach, specialising in trusts and estates work. And I'm also, alongside Simon Goldring, a co-chair of Contra. And this webinar came about in part as an initiative between Thought Leaders 4 and Contra to raise funds for Contra's coronavirus appeal. And as hopefully you'll know when you signed up, the proceeds raised from this webinar will be donated to the National Emergencies Trust Coronavirus Appeal. And we've chosen the National Emergencies Trust because it's a centralised grant-making body which makes onward donations to grassroots charities who need it most. And it's not just about helping those affected by the virus itself, but of course its continuing work is going to be absolutely vital as communities start to navigate the financial devastation left in the wake of COVID-19. So thank you very much indeed. Now, let me move on to introduce my esteemed panelists for today's discussions. If I can invite them to unmute. First of all, we have Philippa Stokes from Rawlinson and Hunter. Philippa is not only a director in R&H's Trust and Corporate Services team, but she's also a member of their Contentious Trust team. And Philippa joins us today as our Paradigm Good trustee. So thank you, Philippa. And as we're going to come on to discuss fraud, I've asked each of the panelists, by way of introduction, to nominate their favourite fraudster. So Philippa, tell me, who is your favourite fraudster?
Jess, for that introduction, and good morning from Cayman. So my favourite fraudster is going to be Frank Abagnale, as who didn't love Leonardo DiCaprio in the film Catch Me If You Can? The cheeky imposter assumed no fewer than 8 different identities, including a police officer, a doctor and a lawyer. Plus, he managed to escape from police custody twice, all before turning the age of 22. Frank Abagnale was so good at fraud that he now runs a successful financial fraud consultancy company, and he actually lectures for the FBI. As a trustee, I think we can learn a lot from Frank Abagnale's story. We are the frontline defence for anti-money laundering, so we really shouldn't be taking a check-the-box approach to compliance. Trustees really need to truly understand the settler's background and source of wealth story, so we can then ask for KYC documentation. The same goes when we are delegating anything such as investment advisors or property managers. I think we really need to look into their backgrounds and not just take the face value of what's on a paper credential. So that's
very good answer. Thank you, Philippa. And next, I move on to Simon Goldring, a partner at Morris Turner Gardner in London, specialising in private wealth disputes. Simon, your favourite fraudster, please.
So my answer is not nearly as polished or exciting as Philippa's. Mine is Sergei Pugachev. If you can rip off Vladimir Putin and survive, you're doing pretty well. And also, let's not forget, he had a massive helicopter.
That was a judicial quote, I think, not just your take on it.
Exactly.
Next, we have James Sheedy, an English barrister and Jersey advocate with Baker and Partners in Jersey. James is described by this year's Legal 500 as having an encyclopedic knowledge of trust law, so please do put that to the test when you're posing your questions. James, your favourite fraudster, please.
My favourite fraudster is actually someone who's accused of fraud, but for defamation purposes, I have to say definitely isn't a fraudster, and that is Robert Chenges, who managed to keep the Guernsey courts and the Privy Council very entertained in the last few years, dealing with issues to do with Article 32 in the Jersey trust law to do with limited recourse. It's been fascinating watching, but a bit of a cheat answer, but still very entertaining.
Fair enough. Thanks. And last, but by no means least, we're very lucky to be joined by Amy Harvey from Peters & Peters. Amy's a civil fraud specialist who's worked on some of the most high-profile, high-value and complex fraud cases of the last decade. So Amy, I'm particularly keen to know your favourite fraudster.
Well, I don't think mine's going to be any surprise. I'm going to choose Mukhtar Ablyazov, who from a professional perspective has created a wealth of interesting case law with at least 9 sets of civil proceedings, 50 interim applications and some of the most creative injunctions and orders sought over the last 10 years. But also from a story perspective, I think he's the only oligarch we all know who was last seen escaping, facing committal, out of Victoria Coach Station on the back of what I believe is a mega bus, although the law did eventually catch up with him, but it's a good story.
Excellent, thank you. Right, well, I've already touched on the financial devastation that we anticipate as a result of COVID-19. And, you know, this title is post-pandemic landscape, but the reality is we're not there yet. Right now, we're still somewhere in the midst of this pandemic. Here in the UK, at least, we're watching the R number very carefully, and we're making calculated assessments as to the expected economic fallout. To put it another way, we know we're down in the dip, we don't know how far down, and we don't know what the shape of that dip is. Economists talk about the V shape, the sharp fall and rapid recovery, U shape, W shape, especially if we have a second peak, or most worryingly, the L shape, a true depression. I had anticipated sharing some graphs, but I'm too nervous about sharing my Ocado shopping list or similar with you. But whatever its shape, it's undeniable, I think, that we now face an economic downturn. And the question is what this means for trustees. First of all, it means that as soon as beneficiaries begin to feel the pinch, trustees will inevitably face increased scrutiny in relation to the exercise of their investment powers and their dispositive powers. And it's not just trustees that come under heightened scrutiny, but also the businesses and financial operations with which they're connected. I think we can expect to see significant numbers of insolvencies and associated trust busting by creditors. And finally, of course, economic downturn and fraud go hand in hand. Amy, I think you'll be the first to say that there's always an uptick in fraud work during a downturn. And as Warren Buffett famously put it, it's only when the tide goes out that you learn who has been swimming naked. And that's it. Economic difficulties often expose existing fraud. When companies go into administration or specialists are brought in to look under the bonnet for the first time, this is a classic way of discovering dishonest practices. And of course, in some instances, it will be trustees who are carrying out these dishonest practices. So that's the backdrop for our discussions. And today we're going to come on to look at the full spectrum of bad trustees, from the feckless to the fraudulent. And we'll be looking at things not just from the perspective of beneficiaries, but of course, just as importantly, successor trustees who may have a duty to pursue claims against their predecessors. But before we do that, I'm conscious that current conditions make a trustee's role very difficult for even the most prudent and experienced. And that's where I want to start. So, Philippa, tell me, how has COVID-19, both the logistical implications of the virus and the financial implications, impacted you as a trustee thus far?
Yes. Well, settlers and beneficiaries are generally normal people like you and me, so their reactions have been very different. Some have been absolutely terrified with the pandemic and have gone out and drafted new wills. Others are much more relaxed. They've ridden market crashes before and they're happy to kind of take the long-term view with the markets. The most concerned are definitely those that are connected to operating businesses that are directly affected by the current environment. And in many cases, this pandemic has exacerbated underlying financial issues. For example, I have one trust structure that owns a UK retail business. And within weeks of the pandemic hitting, the bank involved with that UK business pulled their credit line. And so we've been frantically trying to restructure to make sure the trust assets are safe. As trustees, we are acutely aware that the decisions made now may be subject to increased scrutiny or even litigation in the future. In general, I'd like to say it's business as usual for us. I liked your analogy about swimming naked, and I don't think we do that here. So I'd like to think that we are exercising due skill and careful consideration throughout the pandemic and beyond. But there definitely are a few things that we are trying to be more proactive and vigilant about now. So the number one thing I think is communication. I really can't overemphasize how important communication is to manage the expectations of beneficiaries, especially over investment performance at the moment. This is hopefully to avoid contentious situations down the road. Continuing with scheduled board meetings during this time, albeit over Zoom like this, is really necessary. We've had to check governing documents to make sure that video conferences is actually allowed and to ensure that decision making is still taking place in the jurisdiction. The next thing keeping us busy is ensuring investment reviews are up to date. We've been reviewing investment policy statements and liaising with investment managers to understand the performance of assets and consider the investment strategy. In particularly, we need to be able to identify if action needs to be taken immediately. Similarly, understanding the financial position of underlying companies, even if there is an anti-Bartlett clause, because we need to be aware of the position. I think it's also worth noting that routine administration work has not stopped during this time, and some clients have actually been busier than ever, opening up new investment accounts and restructuring. We've become master negotiators in some ways with banks, especially Swiss banks, in order to accept electronic copies of documents to open up accounts. We've also had to find creative technology solutions to make things work, like having our in-house notary public certify documents over video. We really can't take our eye off the ball and miss any of the normal regulatory and tax deadlines either. So although we're aware that some deadlines like CRS, FATCA, economic substance have been pushed due to the COVID-19 pandemic, others like the UK IHD filings are very much still firm dates with penalties attached. Lastly, careful record keeping is always important, but it's especially critical to be able to support any momentous decisions. And we're very aware that the minutes we are drafting now may be used in litigation to determine the appropriateness of our decisions later. We are, of course, always conscious that we can go to court for a blessing or direction if needed. And the Cayman courts have been very quick to adapt to the new technological rules now with the pandemic. So although the courts in Cayman have been running pretty efficiently, I'm not sure it's been the case elsewhere in the world. And I do worry what would happen, for example, if we were asked to join a case in the UK. I'm not sure whether things are running as smoothly. So maybe Simon might shed some light on what's happening in the rest of the world in terms of access to courts.
So the courts in England have sought to move quite quickly and put out protocols in place that enable cases to be running properly. How well they're running is very case by case, dependent. You have situations where if it is a blessing application where you have no witnesses, actually it's quite easy to run that by video link. I've had similar in the UK and in Guernsey that have both gone fairly smoothly, with lots of test sessions to make sure that the judges are sure it's working, the trial bundles have been tested out. I've also got a hearing next week in the BVI where it's quite a different approach. The BVI approach is that you will get the details to the dial-in a couple of hours, if not 30 minutes before the hearing starts. There is no trialing. If we all dial in and it doesn't work, I'm not quite sure what happens. Now, where it gets more complicated is when you have witnesses, translators. How do you fit in with different time zones? Because typically we'd all be in court together, sat together, and when you say 2 p.m, you mean 2 p.m. to everyone. But 2 p.m. could be 9 p.m. in Qatar if you're in a hearing in the BVI. And so you're having to deal with more logistical issues. However, courts have been incredibly quick to bring in sensible protocols. They've developed and moved from the initial lockdown period where people were making it up as they went along to working out something that now seems to be a sensible practice. Cayman was already miles ahead because the fallout from a number of very difficult storms in the past few years had meant that it had a really good setup already and has perhaps come into its own in that sense. But generally, it's been pretty positive.
James, can you say the same for the Channel Islands?
Yeah, I
Jersey at
can.
least.
I can actually. I'm really been quite impressed actually with the way the Jersey courts particularly have been able to deal with this. I mean, similar to Simon in the very early days, it was a little bit of making it up as we went along. But the Judicial Greffe, which is the court office here, has been very flexible and proactive in making sure that we were on the way to transition towards electronic hearings, electronic bundles and filings, and that has just basically accelerated in the last 3 months or so. I'm trying to imagine what it is, what it will be like if at all we go back to paper bundles.
And Amy, is that your experience in the commercial courts as well?
Yes, and I was going to say, I think whilst Simon said there's been some teething problems, actually what this is, the positive has been that there's been technological changes pushed through quite quickly, which would have taken in ordinary circumstances months or years to achieve, which ultimately, hopefully, may lead to kind of greater efficiency, could ease listing if more hearings can be listed electronically. So I think it's one of the few advantages of the pandemic that we've shown that we can change quickly if needed to.
Now, Philippa touched on briefly making momentous decisions, and I'm conscious that where those decisions are contentious, it can take months and months for the parties to work together and for the trustees to reach a position where they have reached a decision in principle and then go to court for a public trustee and keeper blessing. Now, what happens, Simon, if you were one of those people making such an application in February? You know, if actually COVID hit partway through your decision-making process?
So it's a really difficult point to consider. Is COVID-19 in itself a material change such that the circumstances are so different that your blessing can't continue? Now, I had a hearing in February, which ended up being part heard, and it was in beginning of February, before the pandemic was, you know, really upon us, and before any of us had quite understood the magnitude. And it went part heard to be the second part heard at the beginning of April. Now, by the time we got to the beginning of April, we were in practically a totally different world in a period of 8 weeks. Now, there was a complete and utter division of views of whether COVID-19 constituted a material change or not. Now, in my view, it undoubtedly did. It didn't mean the decision needed to be different. It just meant that the decision needed to be reconsidered. And that
presumably it was a relevant factor that had to now be taken into account.
Yeah, so my view is it must be a relevant factor for any decision that you're making that involves money or money's value, because the world had changed. However, that didn't mean that it necessarily had any impact beyond have a meeting, minute it, put it to the court. It would be circumstance dependent to whether it would have an impact. What it raised for me is a really interesting question, which is, what do you do where it is a material change? Everyone agrees, you know, you had an investment portfolio and it drops 50% through the floor. Do you have to start again? Do you need to take a new decision, reconsider it, come to a different conclusion, consult again with the beneficiaries, so drop your blessing application and have a new one 6 months down the line? But what if this has happened all over again? We're on a V-shaped recovery. So Philippa, how would you deal with that?
Simon, I'd be looking to take some legal advice on that one. But in all honesty, it's very nice as a trustee to be able to go to court and get a blessing or direction, and therefore be kind of covered in respect of future liability. But I mean, I think it ultimately does come down to the trustees having to make decisions sometimes, especially during these sort of when timing is of the essence, especially in a pandemic like this. Sometimes critical investment decisions need to be made, and so often we just can't rely on the court process, even if it is efficient. Or like in Jess's example, where you know, we're looking at going to court and then something else happens and we're kind of delayed. Sometimes the trustees just do need to step up. That's our role, to make decisions. They're hard decisions, but I mean, it has to be done. We've seen some cases where the trustee has been completely paralysed by indecision, and they've effectively thrown their hands up in the air and asked to be replaced. One case recently was in a trust structure where the trust owned hotels, which have been particularly impacted by this pandemic and will be for the next, I guess, year or so. The protector was looking for a commercial trustee to step in because the current trustee was actually proposing to collapse the structure and give the assets back to the settlor. They just didn't know what to do in this current environment. Another common scenario that we do see quite a lot is where the risk profile of the structure no longer fits the parameters of the trust company. For example, if the settlor themselves get into some sort of financial difficulty during this time, or litigation flares up in one of the underlying companies, a compliance department can kind of raise some red flags and say, we no longer want to act for this structure and trustees are looking for an exit. We are very conscious as trustees that doing nothing or inaction can actually be worse than making a reasoned decision. So, as I said, quite often there's time pressure involved, but if the trustee has the facts, they've conducted a reasonable analysis and discussed with their legal advisors, there shouldn't be a reason why they can't come to a logical conclusion to move matters forward and document that decision appropriately.
Absolutely. I think you've hit on our first category of bad trustee, and that's a passive trustee. And it can be very galling. It's very difficult to get traction in those sorts of scenarios because often, a court application won't be a solution, not least because of the non-intervention principle that a court won't intervene unless the trustees surrender their discretion, and courts are not attracted to the idea of trustees surrendering their discretion in any event, and that's before you even consider the time and costs associated. So Simon or James, do you have any sort of creative suggestions for what you might do to break an impasse like this when you are faced with a passive trustee who simply won't act?
I have some experience, and I'm not recommending this as a course of action, but it is desperate times for desperate measures, of a circumstance where the trustee is based in an offshore jurisdiction, the assets are in the beneficiary's basically home jurisdiction, and the beneficiaries, in the face of a trustee who will not act, have basically taken the unofficial approach and just taken control of the underlying structure and the assets away from the trustee in order just to keep them running. As I've said, so I'm not recommending that as a course of action to anyone, but it is a solution, and a practical one, if you're just the levers of power are not being pulled properly.
Yeah. I think that's last resort territory,
yeah,
certainly.
So
Philippa, yeah, that covers passive trustees. If we move on to our next category of bad trustee, those who've committed breaches of trust and breaches of duty. And Philippa, having seen the aftermath of 2009 and how that played out, it would be helpful to think about what sort of breaches we're likely to expect post-pandemic, because I'm conscious that post-credit crunch, many trust litigators, myself included, were approached by beneficiaries deeply disappointed by investment losses. But of course, these sorts of cases rarely get off the ground because, understandably, a court won't be persuaded that the trustee's conduct was causative of the loss, when in fact it was simply a matter of external market forces. So those aren't the claims we would usually expect to see. So what are the sorts of breach of trust claims we can expect?
Yeah, so I think as you said, when the dust settles, I think it will be interesting to see whether there are some more anti-Bartlett clauses being tested. But like what, as you said, it's going to be very difficult to make a claim of a poor investment performance given the extreme market turmoil brought on by the pandemic. This might be a bit controversial, but I actually think that trustees might be open to negligence claims if they are overly cautious during this time. So especially when you think about the negative interest rates on some currencies. So if trustees are simply doing nothing and sitting on cash and possibly losing money on that if there's negative interest rates, I think that's a potential negligence claim there. I think trustees also need to be very aware of their duties should the trustee become insolvent, and they may now owe duties to creditors instead of their beneficiaries. So in particular, there might be restrictions over paying their own professional fees ahead of those of creditors. So that's something else to bear in mind. And the other breach that I think that might come out of this pandemic is surrounding data breach claims. So we've all been working from home, and I guess we all are still working from home, looking at all the backgrounds, and we might be for some time. So this obviously increases the risk of data breaches, and we all know hackers are getting more sophisticated. I had one recently where I got an email from a beneficiary saying that they were stuck in New York and they were looking for a distribution request. Now, the email address was the exact email address of the beneficiary. It sounded exactly the way the beneficiary normally communicates with me. And so I wrote back and said, that's fine, I'll give you a call to confirm the request. And quite helpfully, the email address responded saying, here's my number in New York to call. So they were cheekily going to actually pursue this even further by trying to pretend they were the beneficiary on a phone as well. So I called the beneficiary on one of the regular numbers I had from them. And of course, he was absolutely horrified that his email account was breached and that a hacker was trying to, get these distributions. So I think that kind of just really reinforces that we need to be extra vigilant at this time with data breaches, and also making sure that our policies and procedures cover things like distribution policies. Make sure that you have your callbacks during this time. Like it's just really, really important to get those right.
Yeah, extra vigilance is definitely the word of the day, and I think we'll just have to watch this space in terms of the claims that arise. But coming back to anti-Bartlett clauses, which you touched on, and I don't think we can avoid, I'm interested, we all know that we've now had the final appeal decision in the DBS case. Simon, quick recap on the position there for us, if you will.
I'm not going to go into what an anti-Bartlett clause is beyond a one-liner that we should all know, which is it excludes a trustee's duty to manage an underlying business or investment held for the company. Now, there are two exclusions. It could be excluding the duty to supervise or interfere, or it could be excluding the power. In both cases, those exclusions are unless the trustee has actual knowledge of dishonesty. So going into Zhang and DBS, Zhang and his wife G created a Jersey law trust in 2005. The trustee held 100% shares in an investment company. The investment company engaged in highly leveraged currency speculation, which resulted in significant losses. G, the wife, was the investment manager for the investment company. The trustee's nominee was the sole director of the investment company, and the DBS bank executed investment decisions. G and Zhang sued the trustee for failure to intervene in the management of the investment company, remembering that it was G who was the advisor who had said to do all of this. Now, the anti-Bartlett provision in Zhang and DBS was a wide-ranging no-duty exclusion. It was that the trustee shall leave the administration and management of the company to the directors, and the trustee shall assume that the company is being managed competently. So the trustee did still have the power to intervene. The Court of First Instance in Hong Kong said that the trustee was in serious and flagrant breach of the duty and breached its high-level supervisory duty. In the Court of Appeal, the decision was upheld and said that the trustee had a residual obligation. However, in the Court of Final Appeal, those earlier decisions were reversed. The Court of Final Appeal said that given the terms of the trust, there was no high-level supervisory duty which would require the trustee to interfere, that duty had been excluded in the trust deed, and that even if the duty had been established, there would have been no breach because the trustee had not been grossly negligent. Now, that leads on to a question that I find quite difficult. Is there a residual duty on trustees?
Yeah, where are we now, Simon? I mean, can't trustees now be reasonably confident that a well-drafted anti-Bartlett clause should exclude their obligation to intervene in the management of the underlying company?
So I would say no, because I think that we have gone a step too far in favour of trustees here. And if I put it into context of the pandemic that we find ourselves in, does no duty to intervene mean that if there's a failure to inquire and intervene in the face of COVID-19, is that a breach of that duty? My view is that COVID-19 at least requires a trustee to inquire what's happened in the business. What information it gets back may not require it to intervene, but there's at least that first stage of needing to understand the information, seeing what's happened. If COVID-19 means that there have been material changes, it may engage the duty to intervene. And I don't think that anti-partner clauses should enable trustees to just have a complete protection and a bulletproof way.
I suppose we have to be quite careful about generalising here, because of course there are almost as many different variations of anti-Bartlett clauses as there are trustees, and each will turn to some degree on its particular drafting, won't it? But is that because I think it sounds to me when you say things have gone a step too far in favour of trustees that you're thinking about the policy decisions behind this, or the policy considerations. Is that fair?
Exactly. I think the reason that anti-Bartlett clauses came in was to allow trustees to actually take on these roles such that they felt they were capable of doing so. Beneficiaries, settlors were capable of maintaining control over underlying businesses. But there has to be a balance where the trustees can't just be a silent participant and don't need to do anything.
If my 2 cents here, I mean, thinking about what the usual criticism that goes with anti-Bartlett clauses is by the time you've come to consider whether you need to rely on your anti-Bartlett clause or not, it's probably too late. You've crossed the threshold. And so Simon's proposition that, well, COVID makes the need for intervention, or the need to even look under the bonnet or consider looking under the bonnet, the correct threshold probably means that you're already in trouble already if you're a trustee. But as you say, Jess, the number of ways you can draft an anti-Bartlett clause varies enormously. And if you're relying on something that looks like the one in Jan, where the real risk to you as a trustee is if there's a risk of dishonesty, I'm just trying to imagine in what circumstance dishonesty is going to play a part in COVID. I mean, someone may have made a decision possibly in panic in terms of selling assets or buying assets cheaply in the hope that they're going to appreciate in value at some point in the future. I just can't quite see where the dishonesty is going to.
And James, and what do they do if actually the clause is drafted in such a way that it's not simply the duty that is excluded, but it's the power? Do they have to go to court to?
I don't envy a trustee in these circumstances, because you've got your hands tied behind your back. What else can you do? I think that's the only option that there is, because other than that, you're going to descend into the ring and come off the fence and put yourself at enormous risk. If, for example, there's been dishonesty or something like that, you're not going to have necessarily the tools to be able to put the situation right immediately. So I think the only thing left is to apply to court for directions, however imperfect that may be.
Yeah. Quite useful to think about what dishonesty means in the case of professional trustee, because obviously that's quite a subjective. Everyone will think of what's dishonest in different ways, but from a professional trustee perspective, which kind of develops out of the Armitage and Nurse Authority, and I think there's quite a helpful definition in a later case of Walbrook and Fattar, which is a Court of Appeal one. It's a deliberate breach of trust, but it's not just about knowing that there's a deliberate breach. It can also include being recklessly indifferent, or that the belief that the breach is not contrary to the interests of the beneficiaries is so unreasonable that by an objective standard, they couldn't possibly be for the benefit of the beneficiaries. It doesn't require kind of outright wrongdoing or fraudulent behaviour. We'll come on to what fraud means later. I think so it's probably good to kind of keep that context in mind. It can be kind of reckless indifference. So
Amy, you're there discussing a fraudulent breach of trust by trustees and dishonesty by trustees, as opposed to dishonesty at the company level. And that's, I think, very helpful to keep in mind when we're considering the various breach of trust claims that could arise. And I think it's also at this point helpful to consider the responses to such claims, because I'm conscious that anti-Bartlett clauses are simply one form of defence at the trustee's disposal. James, what are other defences that we will usually see trustees relying on in these situations?
I mean, you're very unlikely this day and age to come across a professionally drafted trust instrument that doesn't have an exoneration clause or something equivalent in it. Certainly, I know that the position is different in Jersey to the UK, and that you cannot exclude for gross negligence. query what gross negligence means, short of getting a trial of the issue. So there's a bit of a risk as to whether you're negligent or just grossly negligent. And then beyond that, I mean, a lot of the offshore jurisdictions have something, this is not so much for beneficiary claims, but for third-party claimants who are trying to maybe bust structures. If there is an insufficiency of assets or trust assets, they can't go after the trustee if you run out of assets because of the doctrines of limited recourse. I think that's pretty much it, unless you're going to get very creative and start asserting as beneficiaries that, for example, you might be able to sue an underlying advisor because they might have a duty of care towards the beneficial class. But I'm not aware of that having been an option in certain...
I've tried it.
So it might be worth a punt, but other than that, I think you...
I suppose I was also thinking of the more preemptive strategies, certainly in terms of investments where duties are delegated, or powers at least are delegated, and last but not least, of course, where trustees are considered to have behaved reasonably and ought fairly to be excused. That is usually the last line of defence. But returning to exclusion clauses, and Amy, perhaps you might help us here, coming back to the question of duties and the extent to which they can be limited. This is a core principle, of course.
I think I touched upon it already. So obviously the Armitage and Nurse Authority, everyone knows that an exemption clause just simply can't excuse a trustee who knows that their omission is contrary to the beneficiary's interests or they're recklessly indifferent. And I've touched on the later authority setting out what dishonesty means in that context. And obviously the rationale behind that is that it's the irreducible core of the trust, is that the trustee has an obligation to act honestly in the best interest of beneficiaries. And if a trust in which the beneficiaries can't enforce this obligation can't be deemed to be a trust. So I'm coming at it from a kind of fraudulent breach of trust perspective, but that's the key authority on that point.
Yeah.
There's an interesting passage in the Jean decision concerning the Armitage and Nurse and its relationship with anti-Bartlett clauses. And I just wondered if anyone had any views on this. I mean, you commented, Amy, that you don't want reckless indifference from trustees, but doesn't an anti-Bartlett clause just encourage reckless that sort of indifference? Because that's the whole purpose of it, is that you don't need to look at what's going on underneath the bonnet.
I think that's why Simon's so upset at the policy decision, because I think that's exactly the effect.
I think it's about striking the right balance, isn't it, between having some degree of certainty. It seems to me from the judgment in Young that one of the great concerns was that if there was this residual, unspecified residual duty, that leads to an awful lot of certainty surrounding how and when trustees should act. But I suppose conversely, we still don't have real certainty over the impact of anti-Bartlett clauses. But this is part of a broader picture, isn't it, about where the balance of liability sits and whether we think it's appropriate. I mean, I'm constantly acting for beneficiaries who are aghast by the level of protection afforded to trustees. And of course, we'll be aware of the set practice rule that requires us to bring exemption clauses to the attention of settlors when making a trust, but beneficiaries won't be aware of that. And I'd be interested to know your views, Philippa, especially as a trustee, as to whether you think we've got this balance right.
Yeah, I mean, as a trustee, what we see in the contentious field is obviously coming in as replacement trustees in these cases. I mean, we're not going to sign something where we're not going to be covered off by an indemnity. I mean, we're professionals at the end of the day. This is our job. We're not kind of, at olden days, trustees were friends of families and kind of taking this on as a loyalty to a friend. We're professionals now, we're in a job, we're not going to take on unnecessary liability unless we do have those indemnities in place.
And I think to do so would simply narrow the market, wouldn't it?
Absolutely. And I think from our point of view, we've seen firsthand where we've kind of stepped in as replacement trustees and when we're looking and having those conversations with the beneficiaries or settlers of the structure and advisors, and they're saying, you know, ex-trustee charged half the amount of what you're proposing to charge, but then when you're looking at what that trustee was doing, it's quite clear if they're not charging the fees, they're not actually doing the job. So I think that there is a line there that you kind of do get what you pay for as well. And you do need to be careful, especially where we've seen if there's an investment firm affiliated with a trust company, and maybe the trust fees have been historically very, very low, but the investment fees might have been quite high. I think they're the kind of red flags that we should look out for.
Yeah. Now, one more question before we move away from anti-Bartlett clauses. Rachel Reynolds asks, she'd be interested to know the panel's view on whether we think the test for inquiry and intervention, which applies in the anti-Bartlett cases, would apply where a power lies with the settlor or protector. To what degree does the trustee need to be satisfied that the power is being properly exercised before giving effect to it? Any views on this? I think, in the sense, is this a question of whether the trustees essentially have to supervise the exercise of the settlor or protector's power? Simon, you look as though you have a
I was pondering. I think it comes to the same point that I was saying before. I think there is a difference between your duty to inquire and your duty to intervene. That it's a fine balance, and I appreciate James's point. Once you inquire, do you fall into needing to intervene? But knowing that the settlor is doing what they say they're doing, or having them confirm that they are doing what they say they're doing rather than knowing the underlying detail, I think is a duty that the trustee must undertake. That's a duty to inquire. Intervention is if they think that the settlor was lying about it or was being dishonest, and that's probably a very difficult line to be able to toe, work out where one interacts with the other. But I think that they have to at least have the settlor purporting to them that they're doing their job.
It's not an uncommon thing, actually, I've come across in slightly different contexts, which is you've got a generation of settlers now who are kind of reaching a particular age, and there's a question as to whether, for example, they've been lent on to exercise a power by someone, by a family member or something like that. So it's a capacity question or an undue influence question rather than have they exercised something improperly or dishonestly. I mean, this is the recommendation all the time to trustees, isn't it? If you've got a doubt, then go to court and seek a direction if you're unsure. But I mean, that's not really practical often. I can't think of what a solution short of that would be if you've got a real concern. Maybe don't do it and let the settler bounce or the protector bounce you into a court application.
Right. It's time now to cross the border, figuratively. So cowboy country, fraud, as we come on to our last category of bad trustee. And I think as we're thinking about fraud and its context, it'd be really helpful, Amy, if you could remind us of what fraud really means and from a legal perspective, what building blocks are needed to make out claims in fraud.
I mean, fraud is something that gets bandied around a lot. We say we're a civil fraud practitioner. That's got a generic expression that has different specific meanings according to the context. But from a legal perspective, it's got a very broad scope and encompasses kind of a wide umbrella of causes of action, but generally involving deliberate actions involving dishonest or even criminal conduct. So from a trust or incoming trustee or beneficiary perspective, the obvious causes of action that people think of often are breach of trust or breach of fiduciary duty, but it also includes the following causes of action such as deceit, so torts arising from a false statement of fact, conspiracy, whether lawful or unlawful means, claims for dishonest assistance, for example, where a non-trustee can become liable for breaches of trust committed by a trustee, where they're accessory to a breach of trust, and restitutionary causes of action such as unjust enrichment. So I think if you're an incoming trustee and there's suspicion of wrongdoing, it's just always good to remember the kind of broad umbrella that may apply. so you can really think about what it is you may be looking to do. And there's obviously a difference between suspicions of fraud and then actual evidence to prove fraud, and that can be quite difficult to cross that bridge, particularly when you're coming into a trust structure or where you're a beneficiary who hasn't been receiving information in the way you ought to.
Thanks, Amy. So thinking about trustees now, particularly in the context of fraud, Philippa, can you give us some examples perhaps of what we might be looking out for?
Sure. A big red flag for us when we're stepping in as a replacement trustee is when we hear that historical records or accounts haven't been made. So we have one case that we're working on at the moment where for the last 20 years, accounting records haven't been up to date. And so when we're looking at bank statements, it's quite apparent that there could be a churning going on with investments, so excessive buying and selling of the same security. And this would have been completely evident had accounts been prepared and presented to the board each year. But obviously 20 years on, we're kind of doing a forensic analysis and trying to work out what was going on. So I think that's kind of our number one red flag when we hear that there's no accounting records or spotty accounting records.
And James, now we're in fraud territory. I think we have to touch on sham. Do you think we're going to see more sham trust allegations in the context of insolvencies following the economic downturn? Sorry, go on.
Well, no, the scramble. There's going to be a scramble for value, isn't there? After all of this, after the dust has settled. I mean, the problem with sham, which everyone knows, is that it's basically made itself redundant because it's such an appallingly high threshold to meet that no professional trustee, the court's going to be very reluctant, I think, in most offshore jurisdictions to find that a professional trustee has been engaged in anything that comes close to sham. We've spoken about before, Jess. I was involved in a case a couple of years back where the trustee themselves said the trust was a sham, and still the court said, no, I'm not prepared to find that, which was unusual. So I think you're looking, I regard sham as a bit of a dead letter.
Certainly for professional trustees, yeah.
Looking, I think, for something maybe on the back of Pugachev. We've talked about Pugachev to death in the last few years, but something like an illusory trust, or maybe if you can interpret the trust document in a way that will get around the firewall. I mean, there's an interesting consequence of the way the court resolved the matter in Pugachev, which is you look at a lot of these offshore jurisdictions and they say, well, you're never going to get through the firewall, you're never going to bust the trust that way. But certainly in Jersey and I think in the Caribbean, the approach to interpretation of trust documents is very similar to that taken in England and Wales. And so if you apply the local law to interpretation, you'll be able to get through the firewall, at least in theory. I've never seen it done.
Well, watch this space. I think it largely depends on the nature of the characters involved quite often in these sorts of cases. Focusing on that, Amy, if we moving on from sham and now consider fraud more generally, whether committed by trustees or by settlors or by individuals operating within trust-owned business, what always strikes me about fraud is that it's something that doesn't immediately announce itself. It's very rare that you discover the full picture straight away. And I think it'd be really helpful to us to understand, how frauds usually present and what are the first steps you need to take where fraud or serious wrongdoing is suspected.
Yeah, I mean, there's always a tension when the client comes to you the first time alleging fraud, where you can see that maybe suspicion, but as you said, it's very unusual to get the full picture straight away, unless you're talking big obvious fraud, rogue employee, for example, who's siphoned money out. That's kind of slightly easier. So it's about starting to get the building blocks together, because when you're alleging fraud, there's a high professional bar. It has to be expressly and specifically pleaded. Barristers have professional duties in relation to making allegations of fraud, as do solicitors arguing under the new code of conduct. So it's about getting the building blocks together and trying to obtain relevant information, which can be very difficult if you have been excluded from the trust or haven't been given proper information. but that has to be tempered by the fact that often delay can be a factor that's taken into consideration. For example, if you're considering injunctive relief, if it's a very serious case. So it's about thinking about the tools that you've got available to you to get to the point where you can make that pleading, and to make that pleading, courts can be asked to draw inferences, but you have to set out particulars of what those inferences are, so that at the stage that you make the allegations, an inference of dishonesty is more likely than one of innocence or negligence. And obviously, in fraud cases, things and knowledge develop as proceedings continue, but it's getting yourself in the best possible position, but as early as possible.
And so where trusts are involved, and if you're acting for a beneficiary, is your starting point actually usually the disclosure pursuant to the inherent supervisory jurisdiction of the court and under usual trust law, and how rapidly do you usually find that you have to reach for more exotic remedies?
Well, I think obviously there are all those disclosure avenues available under trust law, but it's very much whether that's appropriate will depend on the circumstances of the case. You may be in a position where actually you're wanting to get an ex parte order because the suspicion of wrongdoing is so bad that you don't want to be approaching the former trustee or approaching particular parties. You want to be acting behind the scenes, ready to go with your freezing order application in extreme cases. And so you might want to consider other tools such as Norwich Pharmacal relief, which can be done ex parte against third parties who've been mixed up in the wrongdoing. For example, using Philippa's example, if there's been incomplete accounting, getting orders against financial institutions or banks for disclosure of information to allow you to build up that forensic picture. So it really will depend on the particular circumstance in which you find yourself. But from someone who's a fraud practitioner, you're usually going the ex parte route, but that's because it's seriously dodgy people on the other side.
Yeah. I'm just going to flag that we're sort of approaching the end of our allotted time, so please do get your questions in, even if they occur to you now belatedly or refer to something we were discussing earlier. And in fact, on that, we had a question come in, which Philippa, I'm afraid is one for you, because it touches on, again, a very sort of practical consideration. And this is a question from Robert Morse, who says that one of the challenges they find with trustees is that they don't plan for liquidity and known expenditure and fully invest, and then rely on the investment manager to provide cash when it's required. And he asked whether this is driven in part by low interest rates, and would be interested to know your thoughts. Is that fair?
Yeah, well, I guess I should say a good trustee should always budget for expenses, but it is difficult, especially in this environment, to balance your need to invest cash. And also, you don't want to be sitting on a pot of cash that's actually losing you money if you're in a currency that has a negative interest rate. So as a trustee, you're very aware that you don't want to be losing money. So it might be a case of talking with your investment manager and asking to put the cash on even a fixed deposit, so that you are earning some sort of money during this time. You probably have to, USD or one of them that you're able to actually earn some interest on. But I think it is a fine balance, and I think it can be dangerous if trustees do take that approach and kind of put all the pot with the investment manager and then take out as you need it, because there can be penalties even for breaking fixed deposits before the time. There can also be delays if you're trying to get liquidized securities. Like it's not a good solution long term, and I would say you shouldn't put all your money with investment managers, especially if you know that there is going to be expenses in the short term. So that would be my
sage advice.
Something utterly deadly, I think we'll see, which is sort of linked to the question of liquidity, is if you get an insolvency practitioner inside a complicated structure. For example, you've got corporates in the BVI that may hold a liquid assets like property. If you get an insolvency practitioner in charge of that, inside the walls of the structure, they can cause absolute havoc with requests for information, cross-border disclosure orders, and following lines of loans, for example. So many, I'm still astonished after the financial crisis that there are still so many offshore structures with these undocumented loans all over the place that can just be an absolute nightmare for trustees to have to deal with, because then you've got someone who's in control of part of the structure who is hostile.
Absolutely, and we actually have a restructuring team within R&H, so nothing against insolvency practitioners, but they do not think like trustees, and so you do need to be very careful with if an insolvency practitioner can get their hands on assets and direct things.
Right, well, as we draw to the end of our session, and I'm conscious that we're sort of staring somewhat into a crystal ball with quite a lot of anxiety and the prospect of, well, potentially quite a lot of litigation. It'd be helpful to hear from each of you some advice, I think, well, from Philippa and Simon, perhaps advice for trustees, and Amy and James, perhaps advice for beneficiaries, as to how to navigate the uncertainties and volatility that lies ahead. So Philippa, if I could start with you.
Yeah, I guess for trustees, it's to, you know, remain a level head. Remember your threshold to act with reasonable skill and care when making decisions, making sure you're documenting all those decisions, ensuring that your policies and procedures are robust, especially around distributions, and then just making sure that you're doing all the things you should be doing, reviewing investment portfolios, speaking with investment managers, and communication with your settlors, your beneficiaries, your legal advisors. If people are in the loop and you've got good relationships with people, then it tends to not get contentious down the line.
Simon?
What Philippa said, but I would add two things. One is take advice where appropriate. That might be going to an investment advisor, that might be going to a lawyer, but don't be afraid to ask for help. But the second thing, and I would say is the most important piece of advice to trustees in this situation, is still take decisions. Indecision is the worst thing you can do. If you make a wrong decision, but you make it with, you know, bona fide, a good faith and intention on advice, you will have done nothing wrong. You might have made a mistake, but it doesn't mean that you are going to be sued for it. But if you take no decision, you may very well be sued for that indecision.
And James, from the beneficiary's perspective now.
From the beneficiary's perspective, I'd say this. You tend to get, if you're worried and you're looking for information, you tend to get more flies with honey than you do with vinegar. So the temptation might be to then let fire and brimstone rain down upon your trustee. My advice to beneficiaries would be to keep your powder dry and be calm about the situation. You're likely to get much more information, which may lead to litigation or not. Doing it that way, then assuming the very, very worst and going nuts.
Well, Amy, on that. Yeah. That's when they need to immediately, but I think developing James's point and the flip side to Philippa's point, it's about the paper trail. So, you know, all communications could eventually be disclosure in ultimate litigation. If you're a beneficiary who's concerned about ongoing management of a trust or concerned about the actions of a trustee, ask the questions, ask them in a professional way, keep asking, set that paper trail if you're worried. You're essentially lining up potential litigation, and start building up that picture early doors. If you're not getting information, being able to show a court that you've asked on 15 different occasions via email over a period of 3 weeks is helpful evidence. So just always thinking ahead to scene setting for litigation.
Great. Thank you so much to all of you, to my panel, and also to all of you for attending and for helping us build our contribution to the National Emergencies Trust Coronavirus Appeal. Much appreciated. Thanks very much. Bye.